Hello guys, welcome back to our channel Legal Nexus. In this video, we are going to discuss about negligence. Negligence is the breach of a legal duty by omission to do something which a reasonable man would do, or by doing something which a reasonable would not do. So negligence arises non-faces or misfaces. Negligence in the law is thereof a breach of duty, unintentional producing injury to another. The law of negligence is really the application of common morality and common sense to activities of the common man. Reasonable man. In negligence, the term reasonable man means a legal fiction of common law representing an objective standard against which any individual's conduct can be measured. The term reasonable man is used to determine if a breach of standard care has occurred when there is a duty of care on by him. To constitute negligence, any of these essentials has to be fulfilled. The defendant should be under a legal duty of care and skill. Such duty must be towards the plaintiff. The defendant must have failed to perform the duty. The loss or damage must be direct from the negligent act of the defendant. To establish negligence, the injury must be foreseeable, and also there is a reasonable likelihood of the injury. The duty is to guard against probabilities rather than remote responsibility. The burden of proof of negligence is on the plaintiff. Dunlop vs. Stevenson, 1932, is one of the major cases related to negligence. A company manufactured ginger beer. The ginger beer was put in an aqueduct bottle which were sold to the retailer. A purchased a bottle from the retailer and gave it to the lady friend. She poured some of the contents in tumbler and consumed the same. When the remaining contents of the bottle were poured into the tumbler, the decomposed body of snail floated out with the ginger beer. She had a shock and fell ill. She filed a case claiming compensation against the manufacturer for negligence. The House of Lords held that the manufacturer owned a duty to care that the bottle did not contain noxious matters and that he was liable for breach of duty. The duty of manufacturer to take care is to the ultimate consumer. Likewise, in the case of State of Andhra Pradesh versus Rangana and others, in this case, placenta was not removed manually by the doctor even after 30 minutes after delivery of a child, which resulted in death of a lady. It was held that according to the settled medical procedures, when placenta was retained even after 30 minutes after delivery of a child, the recognized procedure to be followed is to remove the placenta by manual procedure. Failure to remove placenta manually by doctor is clear omission, and it is against the recognizing method of removal of placenta by the medical science. Rupees 1 lakh was awarded as damage for medical negligence. Recepta loctor is a maxim related to negligence. Recepta loctor is a Latin phrase which means the thing speaks for itself. It means negligence presumed from the very nature of the accident. The maxim is a legal doctrine that allows a plaintiff to establish a presumption on the part of the defendant without negligence having to present direct evidence of the defendant's breach of duty. In an action for negligence, the plaintiff has to prove not only that the defendant on a legal duty of care to him, but also that he committed a breach of duty. The burden of proof lies on the plaintiff. There are three defenses available to the defendant against an action for negligence. They are vis major or act of God, inevitable accident, and contributory negligence. Vis major or act of God. If by supernatural power like lightning, flood, etc., something escapes and causes damages, the defendant is not liable. Inevitable accident means if the injury or loss is due to unavoidable circumstances beyond the human control, then for such injuries a person cannot be sued under the tort of negligence. Contributory negligence. Contributory negligence is the negligent is not avoiding the consequences of negligence of some other person. When the plaintiff by his own want of care contributes the damages caused by the negligence of the defendant, then he is guilty of contributory negligence. The person committing contributory negligence must have the opportunity and means to avoid such consequences. Contributory negligence is an action to the tort of negligence. If the affected party is also negligent, then the first wrongdoer can raise the defense of contributory negligence on the part of the plaintiff. The last opportunity rule. This statement means contributory negligence by introducing the last opportunity rule. According to this rule, the person who is charged with the contributory negligence may still recover damages if he can show that in spite of his contributory negligence, the other party had the last opportunity of avoiding the accident by taking ordinary care. Davis versus Mann. In this case, the plaintiff negligently left his donkey with the legs tied in a narrow street. The defendant negligently ran over the donkey. The defendant contended that the plaintiff could claim compensation because the defendant had the last opportunity to avoid the accident. Medical negligence is one of the important and sensitive topic in law of tort and Consumer Protection Act. Whether a medical negligence is negligence actionable under law of tort or not was much debated question till November 13, 1995. But the Supreme Court passed the judgment on November 13, 1995 in the famous case Indian Medical Association versus VP Shanta and others, held that for medical negligence there can be claim for compensation under the Consumer Protection Act. Thus, medical profession came to be included under the term service in Consumer Protection Act. Dr. Lakshman Balakrishna Joshi versus Dr. Triampak Babu Godbole, 1969. In this case, the Supreme Court held that a medical practitioner has the following duties when a patient consults him for treatment: a duty of care in deciding whether to undertake the case, a duty of care in deciding what treatment to be given, a duty of care in the administration of the treatment, a breach of any of the above mentioned duty of care given a site of action for negligence to the patient. So that's all about negligence, a key concept in law where carelessness led to legal consequences, whether it is on road, at work, or in daily life. Being responsible matters. If you found this helpful, don't forget to like, share, and subscribe for more legal insights. See you in next video.